Hello, my name's Gordon Farragher and I work for Kaplan Financial. I'd like to share with you a few little snippets of employment law which could be relevant to accounting exams but also might be very useful to you in the workplace. Firstly, how much does your employer have to pay you? Well, they've got to pay you at least the national minimum wage, which if you're aged 21 and over is now £5.93 per hour. It used to be from age 22. The required age fell from 22 to 21 last year. I'm afraid bad news is if you're younger, 18s to 20, it's just under £5 an hour, and if you're 16 or 17, down at £3.64 an hour. From an employer's point of view, the ones who are really cheap are apprentices. They only have to be paid £2.50 an hour for the first year, but the employer does have to supply them with a good training as compensation for the reduced level of salary. Sick pay is an area that is much misunderstood. A lot of people feel they have much greater entitlement than they really do. Statutory sick pay is the minimum amount that you may be entitled to. Now, many people are actually entitled to more than statutory sick pay because of their contracts, but a contract can go down as low as statutory sick pay. Basically, for the first 3 days that you're off sick, you don't have to get paid. I know people sometimes find this a bit harsh, but that's the way it is. You're not working, you don't need to be paid. Once you've been off for 4 consecutive days, now that does include weekends and holidays, as long as you've got average earnings of at least £97 a week, from day 4, then you are entitled to receive statutory sick pay at the rate of £79.15 per week. Holiday pay. Again, the rules on this have changed and become much more generous to staff over the last few years. Going back a few years, there was no minimum amount of holiday that employees had to get. They then introduced a minimum of 20 days, this is going back a few years, which included bank holidays, and then a year or two ago, that got increased to effectively 4 weeks plus bank holidays, but the way it's worded in the legislation is you're entitled to 28 days of holiday per year, including bank holidays. Or if you like, 5.6 weeks. Comes to the same thing. Now, that was on the basis that there are normally 8 bank holidays in a year. Now, of course, this year, because of the royal wedding, we had a 9th bank holiday, and a number of people have asked me, am I entitled to that 9th bank holiday off as paid holiday? And the answer is, it depends on your contract. If your contract says that you get 20 days plus bank holidays, then yeah, it's an extra bank holiday, so you're entitled to have that day off paid. If, on the other hand, your contract says you're entitled to 28 days including bank holidays, which is the minimum the law requires, then I'm afraid that 29th day you don't get. You are not entitled to it as a paid holiday. If you don't work 5 days a week, then you prorate pretty reasonably. Point that people sometimes miss is that the employee can't insist on having the holiday when they want. The employer can insist, if they were really wanted, that all holiday be taken in January and February, and that none was available other times of the year. You know, that the employer is within their rights to do that. Though when staff are on maternity and paternity leave, the right to holiday still accrues. In terms of protecting people against being overworked, that must have been about a little over 10 years ago, the concept of the maximum working week was introduced. And it was decided that it was inherently a little unsafe for people to be asked to work more than a 48-hour week. However, that isn't looked at on individual weeks, that's averaged over a 17-week period. Doesn't apply to everybody, as you can see from what's just unfolded on the screen. If you are basically in control of your own hours, you're the boss, then it would be daft to apply that. It's up to you. You should just make sure you work less, but you know, it's your choice. Armed services, Domestic servants and seafarers are also exempted from this maximum working week. However, I mean, this was quite topical, junior doctors who used to work ridiculous hours, they do now fall within this maximum working week. So over a 17-week period, they shouldn't average more than 48 hours a week. You can, as an employee, opt out of the maximum working week. You have to sign something to say that you have voluntarily opted out without any sort of threat or worry for your job or promotion. If there is any suggestion of intimidation into getting people to sign out, the opt-out is ineffective. However, if you employ people under 18, they can't opt out. They have a maximum working week of 40 hours and there's no averaging. It is illegal to get somebody under 18 to work more than 40 hours in a week. In terms of rest breaks, if you work for more than 6 hours on the go, you have a legal entitlement to at least a 20-minute rest break, which you must be allowed to take away from your normal workstation. Now, the bad news here is you don't have to be paid for it. And most employers don't pay for rest breaks, but you have a statutory entitlement to have that break. If you're under 18, you get the entitlement if you're working for at least 4.5 hours, and the break must be at least half an hour. The employer can decide when the break should be, but it can't be right at the beginning or right at the end, because then it's not a break. And people sometimes wonder about smoking breaks. Is there any entitlement to them? Absolutely not. No, there isn't. And in fact, you can get into all sorts of trouble as an employer if you give people smoking breaks, because non-smokers can then ask for the same conditions, and you really don't have a leg to stand on. You should, staff, have a legal entitlement to at least an 11-hour break between one day finishing and the next day starting. And over a week, an adult worker should have at least 24 clear hours not working, or alternatively over a fortnight, they should have at least 48 hours clear not working. So you can't get people to work for more than 12 days in 14. Basically what that is saying. And the last sort of bit of employment right that I thought I'd share with you in this session is a right to ask for flexible working. Now, don't misunderstand this. Employees don't have a right to flexible working, they just have the right to request it. Now, what is flexible working? Well, it can cover a huge range of things. Working part-time, 2-3 days a week, working between 10 and 3, so you can take the kids to school, pick them up, term time working. All of these are examples of flexible working. Now, if you're an employee, you've worked somewhere for at least 6 months, and you haven't made a flexible working request in the last year, as long as you have a child under 18, or you have a carer responsibility for another adult, you can ask the employer to consider your request for flexible working, and the employer